Okay, Dalaal, go ahead.
Thank you, Ihsan. Welcome, everyone. I will speaking briefly in Arabic for our Arabic-speaking audience, and then I'll switch to English for the remaining time. مرحبا فيكم جميعا. حابة أنوه إنه جلستنا اليوم رح تكون باللغة الإنجليزية، بس موجودة عندنا ترجمة فورية للغة العربية. بتقدروا المشاركين في غرفة الزوم تروحوا على إشارة أيقونة الأرض في الأسفل وتختاروا اللغة اللي أنتم بتحبوا تسمعوا فيها. Okay, so good morning, good evening, good afternoon, depending on the time zone everyone's joining us from. To briefly introduce myself, I am Dalaal Jaber, a US-based international law lawyer and a legal researcher with Lawfare Palestine, which is hosting this event as part of its Jurists for Palestine Forum's monthly webinars and in partnership with the Arab Renaissance for Democracy and Development. We are so grateful for our panelists, Abed Awad and Lamis Deek, who dedicated the time to join us today for a discussion on For and Against Palestinians, Lawfare within the US Judicial System. Welcome. We are so honored to have you among us. I also want to take a moment to welcome our participants in our Zoom room and our members of the Jurists for Palestine Forum who are watching us live. For anyone who's not familiar with Jurists for Palestine Forum, it is a platform that allows lawyers interested in Palestine and international law from all over the world to connect, exchange experiences, and network with leading experts through monthly panel discussions, just like our session today. The forum's main objective is to raise awareness, provide training, and build legal capacity in this area. If you are not already a member, you can go to Lawfare Palestine's website, click on Join Us in the upper right corner to find the forum page with details on the various subscription options. To quickly go over our agenda for today, I will start with a brief introduction to our session's topic. Then I'll yield the floor to our panelists for 15 minutes each. And for the remaining time, we will open the discussion to our participants' remarks and questions. Throughout the webinar, you are welcome to write your questions in Arabic or English, either the Q&A or the chat, or you can simply raise your hand to speak and we will give you the floor. Okay. The extrajudicial killing of the Palestinian-American journalist Shireen Abu Akleh prompted several questions on the US extraterritorial jurisdiction, its duties towards its citizens killed abroad, and duties to prosecute and prevent human rights violations committed using its funds and military assistance, among many other questions. Considering the various US laws that provide for extraterritorial jurisdiction for its courts to adjudicate and prosecute matters involving international parties or of an international nature, the US legal system may offer a base to uphold Palestinian rights and bring Israeli perpetrators to justice before its courts. Our discussion seeks to explore legal and judicial venues within the US court system to bring justice to Palestinian victims, whether American citizens, lawful residents of the US, merely visiting the States, or totally foreigners. Some of the questions to be addressed in our webinar today include: what are the boundaries of the lawfare for and against Palestinians in US courts? And to what extent does the first constitutional amendment guarantee advocacy for Palestine in the US? How far did the anti-BDS legislation go in US courts? What effect does the fact that Abu Akleh held a US citizenship have on targeting her by Israeli forces? What judicial venues and choices do Palestinian victims of Israeli violations have in the US court system? And can lawsuits against US companies participating in human rights violations in the OPT, especially apartheid, be brought to US courts? I'm looking forward for Abed and Lamis to speak on these issues and more. I'm happy now to introduce our first speaker for the day, Abed Awad. He is an American-Palestinian lawyer and former adjunct law professor at Rutgers Law School from 2003 to 2019. He testifies or consults and provides expert reports for courts and attorneys throughout the United States, Canada, and England. He lectures internationally on subjects ranging from law, politics, gender, religion, and culture. He has more than 200 television and radio appearances as a political and legal commentator for numerous media outlets, including the New York Times, ABC, CNN, Palestine TV, Al Jazeera, and BBC. Without any further ado, I will hand the floor over to Abed.
Thank you very much, Dalaal, for that very kind introduction. And thank you, Hiba and Lawfare Palestine for putting this together. And thank you for everyone who is participating today. I have very limited time. And what I want to do is basically try to distill the state of the law regarding Palestinians suing the Israeli government in US courts, and Jewish Americans suing the Palestine Authority in US court, and also both American Palestinians and Jewish Americans suing organizations relating to Palestine or to Israel. So I'm going to cover probably 4 cases. I mean, this is legal in nature, so it'll put a little bit of a framework for further inquiry about potential future opportunities to bring Israelis to justice in the US Forum. So the first case I'm gonna cover, and again, this is gonna be very brief. I have about 13, 14 minutes. It's David Schermerhorn versus the State of Israel. This is a case that relates to the Gaza Freedom Flotilla. If you can recall, the Israeli armies raided that vessel, injured many people. Some actually had passed away and were murdered. And there was a lawsuit filed by members of that delegation that were on the flotilla against the State of Israel. Logically, as we all know, is that if you're going to sue a foreign government, the courts in the US have to have subject matter jurisdiction. And there's an exclusive statute that governs who has personal and subject matter jurisdiction against a foreign government. It's called the Foreign Sovereign Immunity Act. That's the exclusive way to be able to bring a case against a foreign state. Now, for purposes of Palestinian litigation, it's going to relate to some exceptions. Now, all these governments have sovereign immunity, so they cannot be brought into litigation before a federal court. The 2 exceptions that matter to our discussion today is the non-commercial tort exception and the terrorism exception. With the non-commercial tort exception, it basically says that federal courts have jurisdiction in any case, and I quote, in which money damages are sought against a foreign state for personal injury or death, or damages to or loss of property occurring in the United States and caused by the tortious acts or omissions of that foreign state. So the key phrase here, in the United States. Now, the flotilla was in international waters. However, that vessel was carrying an American flag. So the question turned to the court, and the plaintiffs alleged that because we are carrying an American flag, this is an extension of the territory of the United States. And for those reasons, you have jurisdiction, Judge, in federal court to bring these folks and give us a remedy for our injuries. But the case law around the country has looked at the definition of the United States narrowly. So you're not looking at an expansive definition, even though from Admiralty law, you would consider the flag-bearing vessel within the laws of the country that it is carrying its flag. But the court here held that all of the prior precedent took the position that it would not be considered part of the territory of the United States. So just on that technicality and the definition of what is within the United States, the federal court did not have jurisdiction to hear the non-commercial tort exception to the foreign sovereign immunity. The second exception is the terrorism exception. And in the terrorism exception, it basically says that a US court has jurisdiction in which money damages is sought, and I quote, against foreign state for personal injury or death that was caused by the act of torture, extrajudicial killing, hostage taking, if engaged by an official or employee or agent of such foreign state. But here is definition of the foreign state under the statute. A foreign state has to be designated as a state sponsor of terrorism. So on the terrorism exception, the flotilla plaintiffs also were not able to prevail because Israel is not on a state-sponsored terrorism list. So on both of those grounds and both of those exceptions, the federal court was not entitled to hear or adjudicate this matter because it lacked subject matter jurisdiction. So as you can see, we're going to lay out and distill what the law is for further inquiry and research. So that the complaint for the plaintiffs was dismissed for lack of jurisdiction. The next case is going to be Tamimi versus Sheldon Edelson et al., which was a Palestinian group in the West Bank who have been under expulsion. They're trying to clean up they're expropriating their land and their property, engaging in ethnic cleansing. So what the Palestinians did is they didn't sue the state of Israel. They sued these not-for-profit organizations around the US that are funding the right-wing settler movement in Israel that is causing such havoc on Palestinians throughout the occupied territories and even within Palestine 1948. In that particular case, the issue was turned on what we call a non-justiciable political question. So what our jurisprudence in the US says is that when there are political questions, this implicates the separation of powers, meaning that this doctrine of political question will exclude judicial review of controversies that may violate the separation of powers, meaning that the questions are more the authority of Congress and more the authority of the executive. Therefore, they are not definable by a judiciary. Judiciary has no authority to decide these political questions. And our jurisprudence says that these non-justiciable political questions are actually jurisprudential, jurisdictional, meaning if they are implicated, then the courts don't have jurisdiction. So in this case, we're alleging 5 items, the plaintiffs. They're saying that, there's 5 causes of action that they alleged in their complaint, from conspiracy to trespass to war crimes to aiding and abetting in genocide. So the court in this particular case, there was a motion to dismiss based on the non-justiciable political question. At the trial level, the court agreed with the defendants and dismissed it, saying we lack jurisdiction. On appeal, the court agreed in part and disagreed and reversed in part. It articulated the 2 main categories of this political question. The first one was, who has sovereignty over the disputed territory? Unfortunately, under American law and foreign policy, the West Bank, even though under international law is occupied and East Jerusalem is occupied, but according to at least the published decisions that we have in the US, they look at these properties as these areas of Palestinian land as disputed property. And as disputed property, it raises a political question relating to American foreign policy. So on that point alone, those issues relating to who owns the property, what rights arise therefrom, how they were expropriated, they do not implicate legal questions, they implicate foreign policy. And they're non-justiciable and they cannot be before the court. But on the second political question that was alleged by the defendants, which was about the genocide and the ethnic cleansing, in this particular cause of action, the court took the position is the basis of the cause of action is under the Alien Tort Act. And the Alien Tort Act gives a court in the US jurisdiction to adjudicate a claim that arises from the violation of the law of nations. On the law of nations, then we can make this a legal question. This is subject to adjudication and determination by the court. So the court remanded, dismissed the causes of action relating to the disputed territory, but allowed the action to proceed in the genocide, that the settlers are engaged in genocide. I think I'm getting close to my 15 minutes, right? So let me then summarize the cases against the Palestinian Authority really briefly. So in Sokolow versus the Palestine Liberation Organization, the trial level court did find jurisdiction. Like I explained to you earlier, to be able to get in front of a federal court in the US, there needs to be subject matter jurisdiction, and that there has to be a basis for due process under three theories. Either there's general jurisdiction, meaning the defendant is so well acquainted and affiliated with the forum that they would be considered at home at this jurisdiction. The Palestinian Authority and the PLO are not at home in the US. So you can't sue them under that theory. The other theory is the specific jurisdiction. And in that particular case, there has to be an affiliation directly linked between the forum and the underlying controversy. And the underlying controversy here would be the act of violence that took place in Palestine. So this is not related to the underlying, the forum in the US is not related to the underlying controversy. So you can't get jurisdiction against the PLO on specific jurisdiction. The third basis would be that the defendant consented. This is where the law would say in the US, it has to be willful, it has to be voluntary, it has to be fair. So there is no basis for the PLO. The PLO did not consent to be under the jurisdiction. But the pro-Israeli lobby and the pro-Zionist lobby and settlers continue to amend the current laws to try to carve out a by implication and by law definition of consent, meaning that if you're the PLO and if you give martyrs a weekly salary for their families, that constitutes consent to jurisdiction. This definition has been amended 3 times. The Anti-Terrorism Act has been amended multiple times, adopting a new statute as recent as last year. But ultimately, the cases have turned that those statutes are unconstitutional because you cannot convert a voluntary consent into an implied consent by law. So I think that we understand the jurisdictional issue, and I'm happy to answer any additional questions. Thank you.
Thank you so much, Abed, for that insightful intervention. And now we are also fortunate to have with us Lamis Deek. And to briefly introduce her, she is a New York-based internationally practicing attorney whose work ranges from litigation, compliance, and policy work related to human rights, corruption, commercial, and charitable activity. She focuses on cases related to anti-Palestinian state institutional practices in the US and abroad, including recently securing several victories against the measures of the Anti-Palestinian International Holocaust Remembrance Alliance in several jurisdictions. In addition, she defended against manufactured terrorism charges accusing Palestinians. She is an advisor to numerous political, community, and charitable organizations, and regularly represents and advises students and academics facing repression for their identity and for constitutionally protected activity. Lamis, the floor is all yours. You're unmuted. Can you unmute? Yeah.
Thanks, Dalaal. So I wanted to start out by thanking you, Abed and Dalaal and Hiba, for organizing this, and a special tahiyya for Dr. Salman Abu Sitta, Dr. Anis Qasim, the brilliant Suzanne Akram, Diala Shammas, and anybody else I missed. So we had conflicting information. I expected to cover some of the grounds that Abed covered and was told that he would cover BDS. I don't mean to put anybody, especially Dalaal Jaber, on the spot, but I believe Dalaal and Hiba that Diala and I think a few other people here would be brilliant to talk about the BDS laws and maybe some of the Title VI actions, but I'll leave that to everybody's discretion. So what I'll do is maybe a more general kind of overview and context, touching upon some of these cases. I was asked to briefly touch upon Leahy and the role of international law in the US. So we have both Leahy, the Leahy laws and the Foreign Assistance Act, which generally prohibit or limit or provide for various mechanisms when there is military support from the US government to a foreign government that engages in gross violations of international law. However, the problem with both of these acts is that somebody has to enforce them. Now, the Leahy laws have worked, I think, on over 1,000 cases, perhaps more than that, to have a monitoring mechanism and to limit that support. But the bigger issue we have as Palestinians is that this is enforceable by the Department of State. And the Department of State's position, which is the US government's position vis-a-vis Palestine, presents a very strong conflict of interest, which is why we have the Betty McCollum bill, I think that's done in coordination with DCI and CCR, and you can correct me, Diala, which is asking for specifically limiting and monitoring US military support to Israel, or adding the condition that it not go to harass, try, torture children. So the Leahy and Foreign Assistance Act are limited in this sense, and they don't provide a private cause of action. There's nothing that says that any US citizen or somebody generally, or even somebody who is impacted by US weapons via Israel can sue on the basis of the government's failure or refusal to enforce either the Leahy laws or the Foreign Assistance Act. So that's the issue with both of those. Then we have the question presented to me by Hiba, a very short answer, which is, what is the role and relationship of international law to US law? And the answer is simple. First, we start with the general premise that international law is not binding unless it's under two conditions in the US. Number one being a treaty, which can be reversed by executive action. And number two, unless it's codified by US law. And it can be codified by US law through the Constitution, constitutional adoptions of this, by statute for criminal and civil cases, and then also by its application in a US courtroom, i.e. by a case that sets precedent. So aside from these scenarios, we don't really have this binding impact of international law on the US. And the US government's position is, we actually do adopt US law. It's embedded in our Constitution. We do have the Convention Against Torture. It's embedded in our practices, aside from being embedded in our Constitution. But what we also see, which I'll get to later, is that there's an issue of equal protection and enforcement and interpretation of these laws in a very biased, very clearly, explicitly biased way vis-a-vis Palestinians and the entity called Israel. Abed Awad touched upon the basis for the civil suits that are brought in the US. I was preparing as Abed was speaking, so I lost track whether we discussed cases that were brought against Israel or cases that were brought also against Palestinians. Until the Daimler, Kiobel, and all of these cases, which limited the jurisdiction that Abed touched upon, the limited jurisdiction and therefore ability to sue foreign corporations and foreign entities, saying there has to be either that, personal or general connection, and the limitations on that. Prior to that, pretty much every case that was brought against a foreign corporation for actions similar to what Palestinians have brought was not dismissed. It was allowed to proceed. On the other hand, every case that was brought against Israel under these same actions, every single one was dismissed on the grounds of those two, right? That Abed raised, and to refresh everybody's recollection, the political question doctrine, and we'll talk a little bit about that, and then the Foreign Sovereign Immunities Act, right, which is who is a foreign sovereign. On the flip side, cases that were brought against Palestinian entities, organizations, quasi-governments, and corporations up until recently were allowed to proceed. And they were allowed to proceed with an almost schizophrenic and clearly intellectually dishonest application of law and logic to the Palestinian case. For example, I was telling Abed, actually, he recently published an article on the Ari Fold case. And back in 2015, I had written about the Sokolow case, because it's mind-boggling. And this is why, I'll wrap up with giving the political context, because law is not ever void or divorced from the political context. But on one hand, the argument, for example, when cases were brought against the PLO or the PA, on one hand, the judge would argue that we don't recognize you as a foreign sovereign because you're not recognized as a state by the Department of State. And on the other hand, we recognize and we find that you did have the capacity to control this territory that we don't recognize you as being a head of state of. Right? This is the epitome to me of intellectual dishonesty, no matter what legal basis you use to do that. And this should also underscore the malleability of the application and the interpretation of the law that I think people need to take more seriously, but also with a political eye. The political question doctrine, revolves, and Abed, you did a great job, but revolves, there's 6 factors that are called the Baker factors, but it revolves on does the judge have to make a finding on an issue that is quintessentially reserved for the executive or for another branch of government? Is there a policy finding that the courts have to make that either broaches on the separation of powers or contradicts them, right? And the factor that is that says we can't contradict them is quite funny, I think, in the naming of it. And I think it's something to the effect of, when you're weighing these factors, you weigh the potentiality of embarrassment from multifarious pronouncements from various departments, right? Is it going to be embarrassing for the court to issue a decision or make a finding that would be an embarrassment in its conflict or difference in position from, for example, the Department of State or Congress? And this is very telling about how the political question doctrine has been invoked. So the political question doctrine was not invoked simply based on these factors. To the contrary, it was largely invoked based on mostly based on this factor, right? Which is political issue and contradiction of US Department of State position. So we'll look at a couple of cases or I'll talk very briefly. Abed addressed a few of them, but the Rachel Corrie case, we're talking about a US citizen, a white woman from Seattle, Washington, who was murdered by Israelis using a caterpillar. And she didn't sue the Israeli government. Who her family sued was the company. And this is, I believe, before the restrictions and limitations on jurisdiction. And in that case, the court said, okay, political question doctrine, it's an embarrassment if we say Caterpillar, not the US government. Caterpillar as a private corporation is liable, is an embarrassment. Political question doctrine, that's number one. Then they also said that they went further on this factor and they said, this is a delicate issue of diplomacy. We have to find a balance. And then they also said this would be, if we found otherwise, this would be a contradiction of US foreign policy, because US foreign policy and the US government did not prevent or prohibit the sale of Caterpillar bulldozers to Israel, right? This was the basis for dismissing the case of an American-born, American white woman suing not the Israeli government or Israeli actors, but suing a US corporation. You look at the cases, you have the case of Furqan Dugan, I think that's the one that you were referencing, the 19-year-old US Turkish citizen murdered on the Mavi Marmara, I don't know, 2011, almost to the day. It was Memorial Day that he was murdered. And then you have 2 Palestinian teenagers 14 and 16 years old, Urwa Hamad and Nadim Nawara, US citizens who were murdered execution style, again, dismissed for political question. We have these same exact fact patterns with other governments and other military agencies in which the cases were all allowed to proceed, I think excluding one. And I'm not just talking about Iraq and Afghanistan, I'm talking about Nicaragua, I'm talking about other governments. Not that they're necessarily governments that this government, our government, perceives of as friendly, but legally speaking, if we're having the same analysis, there's a very clear, intentional, political, biased contradictions before the limitation of jurisdiction. The same thing, going back in the day, the Tel Oren versus the Libya case, right? It was a political decision very explicitly that Palestinian resistance does not constitute an act of war. Whereas in the case of Nicaragua, Nicaraguan Contra's resistance was considered an act of war, and the case was managed appropriately, right? Another finding in the Doe versus Israel case, super political, probably would not happen in any other situation, where the court found that the issuance, it's a sub-issue, but very important, that the issuance of bulletproof vests did not arise to any form of arms, So that's like saying, if I gave a known criminal gang home invaders bulletproof vests so that when they came into my home and I attempted to defend myself, my home, and my family, them wearing bulletproof vests is not contributing to any act of aggression, but it is strictly and simply and purely defensive. I mean, this really bends, logic by all means. And the reason that it bends logic, look, granted, and we'll talk about the limitations of jurisdiction and the it's the Promoting Security and Justice for Victims of Terrorism Act, which is the act that was specifically legislated to make Palestinians an exception to due process, and how that might impact the Sokolo case. But essentially, we're looking at these technical legal excuses, whether it's political question doctrine or jurisdictional issues or Foreign Sovereignty Immunities Act, whether it applies or it doesn't apply, right? Because it's used as a double-edged sword. It doesn't apply when it's Palestinians that are being sued, but it does apply when it's Israelis, even if it's within the occupied Palestinian territories. And that's because these are technical legal excuses for a political purpose. Period. And it really cannot and should not be understood any other way. That doesn't mean that we don't engage and look at and try to maneuver through these technicalities and try to craft the best cases, because there's also a risk for some people here who are with legal organizations, and we were having these conversations with organizations who were bringing cases. How and when do you bring a case? Under what circumstances do you bring a case? What is the political context? What movement have you mobilized before you bring a case? Because if you bring a case and it fails and we get a bad precedent, you're not just impacting your client or your organization, you're impacting the whole of society. You're impacting specifically Palestinians in the US and more broadly Palestinians, right? In the cases of people who are bringing, cases vis-a-vis terrorism. So these are things that we need to always consider. It's not just a matter of here's a jurisdictional issue. What are we talking about? We're talking about the ATA, which Abed raised, under which, TVPA and all of this comes, the Torture Victim Prevention Act. Well, the Anti-Terrorism Act is also the same act that designated Palestinian organizations, Palestinian political parties, even their charitable and social services wings, as terrorist groups, right? So this same act under which we're supposed to be able to sue is the same act that says, oh, hold up, 75 or 90% of Palestinian organizations and actors or affiliates or coordinators are terrorists. Issue number one. Issue number two, what is terrorism, right? Very famous decision, New York Court of Appeals, and I've done these terrorism cases, and many of you here, some of you here have done these terrorism cases, and what did the Court of Appeals in New York say? Says, look, we can't clearly define terrorism, but it's like pornography. I know it when I see it, and I know it when I see it, and then they named 7 examples, 6 of which were Muslim cases, right? And there is no widely agreed upon, clearly defined definition of terrorism internationally, right? And then you have your run-of-the-mill, reflexive, normalized anti-Palestinian violence and I'm sure everybody knows, but let me make it clear, there is no judge, there is no prosecutor, there is no attorney that is not impacted by the dominant anti-Palestinian discourse, right? This is just the reality of the world. And the Sokolow case is a prime example of how anti-Palestinian bias played a very central role in bringing a decision against the defendant. How was this run? You look at number one, right? We talked about how the US government says, oh, we abide by international law. We follow the Convention Against Torture. We don't allow testimony, admission of evidence that was deduced by torture. In the Sokolow case, like in many terrorism cases, like in many immigration cases, Palestinians are the exception. Israel was able to bring in, and the plaintiffs were able to bring in evidence that was deduced specifically under torture of Palestinians, right? And to bring in secret sourced evidence as well, while at the same time prohibiting the defendants from bringing in any information about the acts of violence, occupation, domination, and subjugation by Israel, right? The full context from the defendant's side was removed. Then they told you, here's this evidence based on torture about why all of these people are so awful, but let's do one better. And this was a big thing post 9/11, especially in the early days of the terrorism cases, where the prosecutor or the plaintiff would say, oh, look, judge, this is a very dangerous case. We want the jury to be comfortable. So what are we going to do? We're going to give you an anonymous jury. So you jurors don't need to have names, and you need to know that you're being protected and that you're going to be anonymous because this is very dangerous for you. And this serves the purpose of doing what? This serves the purpose of intimidating, scaring, and creating automatic, almost incircumventable prejudice against the defendant from before the case starts, as if the rhetoric and the narrative that is dominating society wasn't sufficient. You now have an absolutely terrified jury being told, oh, no, there's no such thing as Israeli oppression, and this evidence brought under torture is admissible. This is what happened in the Sokolow case. And I'm going to beg to differ slightly with Abed on one issue. I read your article, is yes, I think, the decision in the Fuld case is promising, but there's a couple of factors. And this brings us to judicial bias. And Judge Martin, who was sitting on the Sokolow case, is certainly a very different creature from Judge Jesse Furman, who was sitting on the Fuld case. Judge Furman is actually quite well known as a very liberal. He's known even in my legal circles as being, somebody who really does take the law seriously. He tries not to make exceptions and contradictions to a very obvious extent, and he has liberal leanings despite, and I'm not saying that he's pro-Palestinian or anti-Zionist in any way at all. I don't believe he is. I don't think he is, but he does have a liberal tendency, right? So Judge Furman, who gave us this decision, finding the PSJVTA unconstitutional, right? Even him still kept the door open for a finding. But at the same time, when we look at the Sokolow case, yes, okay, we're going to say, hopefully, it goes before Judge Furman and not another judge who can test the constitutionality of this. But if we're looking at an issue of liability and proximate cause, no. It's well within reality that evidentiary findings, because we always exclude that. We say jurisdiction, we say what are the laws, but evidentiary findings are super discretionary, right? Yes, there's the law and you can appeal them, and certainly no judge wants to be appealed. But evidentiary findings, what you can bring in, what you can keep out, what you could say, the framing of the case, and decisions on them, and decisions even on whether Palestine is occupied, right? I think most of the attorneys here have been before judges, especially in the early days of the 2000s, where judges say, hey, what's the difference between, Jenin and the Bronx? I don't see a difference, right? But evidentiary findings are very critical, and these are very much within the discretion of judges. Yes, there are limitations, but let's be realistic. And so what does this all say? We have to look at... I
just want to know, as much as this is intriguing, go for it.
Yeah, so ultimately, look, the law is not the highest stage of policy change, it's the second highest stage of policy change. The highest stage of policy change is establishing a normalized normative dominant discourse. This discourse, this discursive struggle is also the first and the lowest stage of policy change, which means that when we're looking at cases, it's myopic and quite frankly stupid to not consider building the political context, right? And this kind of jury influence, this judge influence in advance, number one. Number two, yes, we have these limitations. I think what we need to do is to consider, and I think a few of us here are working on this, is to consider what are the other avenues that we could take. Yes, certainly genocide and war crimes and apartheid are illegal under US code. Who's enforcing them? What can we do to build towards that, right? On the grassroots level, but also engaging the various assets of government. No agency, no system, no branch is a monolith. These are systems made of parts. Where do we make wins? Not just in the US, but internationally. In closing, and then I can build in where I came in because also my throat is getting dry. Two things. Power only concedes to power. And this is a game that needs to be played inside of the courtroom and outside of the courtroom. And how do we build that power? And thinking more broadly about what that looks like, building up to these cases. And I wanted to talk a little bit about IRA. I mean, IRA is an anathema, but we've been able to make gains against IRA. IRA is one of the grossest violations of equal protection for Palestinians. It's a prima facie breach of the First Amendment right. Made as an exception for Palestinians, and the US has a long history of doing that. I'm going to just give a few examples, please. 1972, right? The NSA can give information to Israel on US Palestinian citizens, right? 1979, the US reversed completely its anti-extradition laws where there's a political issue, specifically to allow the extradition of Palestinians. The 96 Oklahoma bombings by a white man who was held without charge and on secret evidence, longest held as well, were Palestinians. All IRA, same sort of exception, right? So what we need to understand is, number one, there are avenues to challenge these that we need to start being really strategic about. And lastly, in closing, I want to say, no case and no cause is won by a single track. No case and no cause is won by either intellectual laziness or timid, right? Every case, every cause is won by the brave. And I would say that this is the time for bravery, not just on the political, but marrying the political and the legal in a way that's strategic, strong, and unashamed, unembarrassed, and unapologetic while looking at the technical and how to manipulate that. Thank you for letting me go on, Dalaal.
Of course, thank you for that stimulating intervention. I'm sure we're gonna have some follow-up questions. To quickly remind everyone as we go into our discussion, participants' questions, comments are welcomed. You can either write them in Arabic or English in the chat, or just raise your hand to speak and we will give you the floor. Perhaps we can first take 3 questions and then hand them back to our panelists to answer or reflect on, and then we'll take another round. Go ahead, Suzanne.
So since there's silence, I might as well start. Thank you very much, both of you. This is really helpful. And I guess I was trying to figure out, in terms of the papers for this audience, what the purpose was of the way the papers are framed. In other words, are they a suggestion that more lawsuits could be brought? For example, that it is possible to bring a lawsuit on behalf of Shireen. And the reason I'm asking that is that, as Lamis has really pointed out, and Abed as well, the field is incredibly complicated, and it's much more complicated than I think the papers reflect. I mean, I've been in this game for a very long time and been involved in a number of the big cases against Israeli defendants, as well as what part of the network after the Oklahoma City bombing and IRA and the secret evidence cases. I litigated one case for 21 years in which the defendant wasn't Palestinian, but was Arab Muslim and was in detention for 4 years under secret evidence. And I think if our purpose is to map the issues, then I think we have to do it very, very systematically and very clearly, because everywhere I go, I get these questions. Can we bring a lawsuit for X? Can we bring a lawsuit for Y? One of the most common questions I get is, why can't we sue for Palestinian land being taken in the United States, right? These are incredibly complicated questions, and not just for the reasons that we've heard today. In the Corey case, I worked on the Corey case with CCR, and really the issue came down to the approval of the Caterpillar contracts to Israel. It was that approval that was presumed to be a statement by the US government that this is a foreign political question. And in the Belhasvi Yalon and Matar versus Dichter, both of those cases were also dismissed, not because of the political question per se that the court was deciding, but because the State Department submitted letters of opinion that this was a political question, unsolicited, and of course not parties to the case. So I know for some of us, and there's some other cases that I've been involved with lawyers thinking about bringing, for example, a case against the Utah-based church. Everybody knows the big
the Mormons.
Mormons, yes. I think we brought you in on that discussion, didn't we, Dalaal? Okay. So what we were looking at was whether the lease agreement, because it was signed in the United States, executed in the United States, could be the basis of a lawsuit. And after a number of years of going around and around on the theories, we decided that was too risky to bring. So I'm just saying all this because I think it's really important for us to situate our discussions and the pieces that we write to not simplify the issues and to make sure that, as you've done today, you bring the lawyers who've worked on these cases and talk to them, because I think many of us would say it is going to be the rare case that I would say is a good case to bring right now in the US context, other than cases in which we are litigating issues that are affecting us within the United States. Like the First Amendment cases, the freedom of speech, the BDS cases, those are good cases to bring. The risks are not there that we have for these cases where we're talking about foreign defendants and possibly foreign or dual national plaintiffs. So there's a lot more to say, but I'll stop there. Thank you so much for both of you.
I agree with Susan. This is extremely complex. My objective is to possibly learn from these latest few cases in the past couple of years, specifically on the jurisdictional piece, because I mean, that's the foundation of your case, is trying to get in front of a court. So I think there is much to learn from these cases on the jurisdictional basis and build on. And Sokolow, just a couple of months ago in March, on the remand from the Supreme Court, the same judge, Daniels, who had agreed to the the $650 million judgment, just dismissed the case just 2 months ago, finding that there is no jurisdiction and that the new statute amending the ATA does not grant the district court jurisdiction. So I think there is some momentum and there is some clarity coming out of these cases that we can potentially build on for future litigation. But I agree with you. It's unless it is territorially situated in the US, it is going to be hard. And your only avenue is the Alien Tort Act and looking at international law, but everything is political. I mean, the entire first part of the decision in the Sheldon case is defining that it's disputed territory. And this is how the judge is going to go ahead and start his case, already assuming disputed territory. So we have an uphill battle, and it's hopefully with the litigation acumen that you and Dalaal and Lamis have, hopefully we'll find a way in. There is the Sheldon case is still alive on the genocide aspect. So who knows how that's going to evolve.
So I'm just going to be brief. Thank you, Abed and Suzanne, for your life of work. I can't count the number of cases where you're listed. You make us incredibly proud. But I do want to second, because I've struggled with this even early on in my career and even in law school, is really measuring not just, okay, and I strongly second actually your point about maybe considering stepping away or having more targeted goals when we bring civil suits, right? Something really targeted. Am I going to come out with a decision on a sub-issue? Is that my goal? And be realistic about that goal. And also, it's super critical. I keep saying this, whether it's the terrorism cases, to give you an example, we had the demographics unit. Dalaal and a few of you here are super familiar with this, right? And we had all these terrorism cases for all of these years. And then all of a sudden, we were getting sympathetic statements. Everybody knows my position on FBI and DOJ, so I don't need to make excuses, but we were getting sympathetic statements from the FBI. We were getting sympathetic coordination from various bodies who should not have been coordinating with us. Why did this happen? This didn't happen because there was a sua sponte change of heart and mind in the world. This happened because there was a strong political movement that we were mobilizing at the same time that we were bringing defenses of these cases and creating a new narrative. So twofold. Number one, have a clear, sub-issue target, have a mobilized, strong political movement that can reach the judge and that can reach the jury and that can be a source of pressure, ya jama'a. Number three, above all of this, it's so important to understand the precedential effect of these cases and the amount of resources that are being dumped in this. And I worry oftentimes that people aren't really considering this. Number four, what other jurisdictions and avenues do we have? If civil is not the way to go and nobody is enforcing the criminal, right? Because it is a violation of US federal criminal law to colonize and invade somebody's house and to engage in apartheid. What we need to focus on is how do we up the pressure in this regard? I got this funny phone call a couple of months ago. Some people here might enjoy this, for a client where FBI agent is calling to say, hey, I don't want to ask your client about his political activities. What I really want to ask and what I want to know about and what I want to let him know is if there is an Israeli operative that is acting or around your clients, or about these foreign operatives, let us know. Okay, that's funny because my question was the ones that you're working with or the ones that you're not working with. But at the same time, this is an avenue. And I think we need to be a little bit more creative with how we proceed in terms of which avenues we are using, which countries, which cities, which states, which judges, for God's sake, how many people are bringing, conflict of interest issues. How many judges have people here been before who have family in Palestine, whose family are colonizers or whose family are in the colonizing army? People aren't bringing this. And this is what I was referencing very subtly with you have to be brave and you have to do these things. I don't think now is the time for it. I think that there is a political shift. When I first started trying these cases, the minute that somebody said Palestine and Israel and terrorism, people were terrified. The jury was terrified. And then I went to as far as long ago as 2012, 2013, 2014, where, when we're voir direing the jury and we bring up the issue of Palestine, Israel, I had young white Jewish kids giving lectures about apartheid and colonization. So there's been a shift. Is it a shift significant enough to change DOS intervention? And Suzanne is right. The DOS and the executive is intervening and saying, no, but they have intervened. They intervened in cases against Iraq, Suzanne, sua sponte of their own accord. And even then, the judge said the judge said, no, it's not a political question. We are going to let this case proceed because it wasn't Israel, right? So even when they intervened in other cases, so let's understand that this history is not in the past, it's current. We still have exceptions for Palestinian humanity and equal protection in the law, in the criminal sector, in the civil sector, in life generally. And we have to understand that that's our reality. What do we do in other ways? Sorry, Diala, you were going to go. Go next. Diala has had her hand up. Asfe.
Sorry, I actually have to jump to another meeting at once. I don't want to. I don't want to take up space, but I just wanted to thank you all for convening this, and really great set of remarks by Abed and Lamis as always, and Susan.
Yeah, I'm so sorry. I should have conceded. And
I came to learn, so thanks.
You have mountains to teach us. Okay, as does Susan.
Thank you all. Sorry to jump.
Thank you, everyone, for your remarks. Wow, what a passionate discussion. I was thinking about all these comments and honestly stimulated by the various aspects that need to be considered in our strategies and movement and the correlation between power and politics and the courts. Anyone else who would like to jump in with a comment or a question? Okay, I get, oh, Suzanne, go for it.
Yes, only because nobody else has jumped in. I want to pick up on a couple of pieces of points that Lamis made about really the importance of having a mobilizing advocacy and publicity campaign that precedes bringing the lawsuit. In both the Belhas Ya'lon case and the Matarvi Dictor case, there was a blackout on press. We could not get a single press mention of the cases. And not that we didn't try, and we had press conferences, but nobody was going to publish about these cases. So I think that's something really important to reinforce. And I have long ago given up the idea of a lawsuit as a kind of a goal in itself. And, you know, besides all these other legal considerations, there is the mobilization consideration that is absolutely critical. And yeah, we shouldn't be contemplating cases on behalf of Palestinians without that kind of advocacy. And then just based on the papers, there was one really point that struck me, the second paper, which was that it seems to confuse, just for those of us who haven't been involved in US cases, it seems to confuse civil versus criminal litigation. And we don't have universal jurisdiction as a criminal issue, as criminal cases in the US, unless it's brought by the Justice Department. And well, in my wildest dreams, right? But so universal jurisdiction is solely the Alien Tort Claims Act. Basically, that's what we're talking about. And that confusing that with sort of evidence gathering, which I saw in the second paper, evidence gathering and sort of culling evidence and interviewing claimants, that's not on the horizon for a criminal case. We're talking about civil. So I think that's a really important distinction that people don't quite understand in the US context, which is different from the European context. And one more piece that was raised that I want to just share a really great mapping resource, which is Wadi Asaid's work in which he mapped what has gone on behind the terrorism cases that have been brought by the Justice Department. And exactly Lamis's point, he says again and again that there were witnesses brought from Israel whose identity was not disclosed and who swayed the judges and weighed in on the evidence. And so that's a factor that I think we also need to keep in mind. So that's it for me. Thanks.
Right, and this happened in the civil case. I don't know what these documents are. I haven't seen the papers, Suzanne, but that happened in the Sokolo case, a civil case, right? We're all convention against torture except for Palestinians, right? Arabs, Muslims, but really quite specifically Palestinians. I second and third what you said, Suzanne, and I want to say, Yani, it's my stubborn, perhaps naive hope that in your lifetime, we will see, whether it's in the US or elsewhere, the beginning, inshallah, of prosecutions, stuff that circumvents foreign sovereign immunity, if not in the US, elsewhere, or at least the beginning of the pressure. This goes back to the first stage of policy change being the discursive. It's also the mobilizations of pressure around these issues. You're not enforcing, you need to be enforcing. Why is Justin Yaakov Fauci, a Long Island-based, born New York bred, engaging in war crimes with abject impunity? How does this impact? So this is along the lines of the work that I'm interested in. I'm not interested in the civil lawsuits for all the reasons that you've raised. I think I'm a little bit tired of the terrorism cases, though, we saw recently, right? I always tell people the Democratic administrations are the most anti-Palestinian when it comes to legislation. They de-designated the Kahani group, right? I mean, this is an outrage. It's also an opportunity. I hate to say that. It's also an opportunity. So those are the lines that I'm thinking about, Suzanne. And again, to so many of the attorneys here, but really you're an inspiration. And I always love seeing your name anywhere. And thank you. I can't thank you. You're a giant to me, Suzanne.
Thank you so much. Listen, it takes a village.
It's
does.
All
of us. It's all of us. We're in this together.
Yes.
Well, thank you both. Thank you, Suzanne, for sharing your insight. And we're always thrilled to have the perspective of a professor who has such a long-standing history and commitment towards Palestinian rights. I'm going to share a couple of comments that were dropped in the chat. One from Diala before she left us, and she mentioned that she was happy to share at another time, if someone wants to reach out to her, or maybe we'll host her, that what we're seeing in terms of the use of the ATA against Palestinian clients in the US beyond the PLO cases, and to think that with you about all the opportunities for creative interventions, seconding the importance of political mobilization and a clear set of articulated goals at the outset. Another comment from Professor Salman, who wrote, "It is clear that resort to law in a biased or hostile jurisdiction is futile. The answer may be an occupied people's resistance, like the 1968 to 1974, which forced the issue at the UN eliminate meaning of disputed land and terrorism." Yeah. If Professor Salman wants to, I don't mean to put you on the spot, but if you want to talk about this more, or anyone has a remark on the topic, I would love to hear that.
Okay. So if nobody else has a point, this just raised one more issue that I think we haven't touched on, and that is the consequences of bringing these cases on victims. And I am still haunted by our efforts to bring justice to the families of the 100 people who were massacred in Qana. And 55 of them were children, and children of our client in Detroit. Those people had, just simply by the fact that we were working on this case, had extremely high hopes. And we couldn't even get to trial. I don't want anybody to forget that bringing cases also raises expectations. Yes. And that is something, a factor in and of itself, that has to be really, really carefully considered.
Yes.
Because I know till this day, every one of those families is suffering, and we failed. in their eyes. So if we're going to have any promise that the law has some relation to justice, we also have to be careful to factor the risks of losing and the consequences of that on the people who are suffering. So it was just one point that we didn't raise, and I think it's an important one.
Critical point, you know, and we see this even in the, you know, academic and school cases and all of these other cases, is that the prioritization of the political end goals while forgetting the humanity of the client. I mean, this is so standard, especially when folks are so movement-based or issue-based, that we forget that the personal is not separated from the political and vice versa. But this is super, super important. And thank you for always, you know, especially in institutional work, I feel like people forget that there's not only the individual, but there's also a community command that's impacted by these cases. And people need to take that more seriously. I'm seeing institutions kind of now looking at coordinating with Palestinian communities or Arab and Muslim communities before bringing these cases, but it was a lot of pulling teeth where there's this, you know, nice, sexy case and we're gonna make the news and we're gonna say free Palestine in a courtroom. Okay, lovely. But what is your long-term impact on all of these people and the communities that they represent? So this is not just important, but essential, critical. Sorry, I keep going after you to second everything that you're saying, Suzanne. This is muhim jiddan.
No, it would be fun to have a roundtable, you know, of a whole group of people who've worked on these cases from the movement side to the legal side, and really have a brainstorming session. It would be fantastic. We don't do that.
A retreat would be great. I mean, I've been considering trying to organize one, so maybe we could talk after, either later in the summer or the fall, something curated, goals, all of this, a nice weekend retreat to just go through this.
Sounds good.
Great. You don't understand how happy that makes me, Suzanne. Yeah.
Wow. I'm so happy that these ideas are coming out of our discussion today. I'd love to see, honestly, a roundtable that sets a strategy for not even yourselves, but also the generation that's coming after you and how to navigate this space. And thank you so much, Suzanne, for bringing up the humanitarian aspect, and Lamis for confirming. Yes, we do tend to get so occupied with the law that we forget the humanitarian aspect of the suits we bring. I will end with one final question, a question for our panelists or whoever wants to comment on. One of the questions that we had hoped to answer by our discussion today was, can lawsuits against US companies participating in human rights violations in the OPT, especially apartheid, be brought to US courts? I'm sure that I've heard about cases brought against companies overall, but perhaps on the apartheid aspect, if anyone has insight.
Suzanne, I'm going to defer to you. I mean, I think we're going to have the same answer anyway.
Well, yes. I mean, I think if we haven't prevailed on war crimes, I think it's highly unlikely we're going to prevail on an apartheid theory. And not because the law isn't stronger on apartheid per se, but it has to do with the complexity and controversial nature and what you have to prove for apartheid, given all of the factors that we've talked about, that I think this is the wrong time in the United States. What's the right time is to do a lot more writing and a lot more publicity and a lot more community forums and seminars and conferences, putting apartheid as a framework at the forefront. I don't know if anybody remembers, but way back when, we had 3 conferences in Boston on one state. And it really, I mean, of course, there were lots of problems. The Harvard pulled its funding out of the conference that we had there. They managed to scramble and still have it held. But these are important, having the discourse in the public and changing public perception. That we need to do. I think it's not the right time for a lawsuit based on that theory.
I agree with Susan, and just as Lamis, I agree with Lamis and highlight it more, the political cannot be detached from the legal. And you could look at the political as the grassroots building, the legal as the fruits of your labor. So unless we have a clear political movement to raise awareness about these issues, I just started the first super PAC. It's called the Truth Project in New Jersey, with the hope to start raising the awareness on the issue of apartheid and getting the public aware of these issues. In addition to all of the lawsuits that, you know, Susan, I agree with you wholeheartedly to be very reluctant to move. It's not the time, and I agree with Lamis. But we also have to think about the cases that are against Palestinians. These cases that are chilling, you know, speech and the ability of the community to feel comfortable advocating on Palestine. So these are things that I think there is room for us to fight back and build that. So let's not forget about all of the lawsuits against the PLO, the PA, and against our Palestinian organizations. And wait, and take this prediction from me. I just came back from Palestine, and there is going to be a implosion. And you are going to see members of Fatah, for example, moving towards armed resistance. And all of these Palestinian American organizations who have been, you know, hosting PA folks, hosting members, they're going to become targets. It's just a matter of time that we're going to have a slew of these cases against Palestinian Americans, aiding and abetting terrorism because we're sending money to our relatives or family in Palestine. So I think that's going to be another area of concern for us.
I want to pick up on that. I mean, I always tell people I get very nervous when there's a Democratic administration, because there's nobody better at accusing Palestinians of terrorism than a Democratic administration. We're already seeing the resurgence of the entrapment cases. So I don't even think it's going to require the full, sorry, I had to take my blazer off because it's quite hot in my apartment. So I think we need to be ready for that preemptively, in a way, as a legal community, looking and preparing for that, but also kind of learning a lot of the lessons that, you know, came out of the terrorism cases post 9/11. That's super important. Building from Abed's point about looking at the cases that are the civil cases that are being brought up against Palestinians, what we saw from a lot of the cases that were brought either against the banks or the PA and the PLO prior to the jurisdictional restrictions, because one of the other factors of you can bring any case you want. Is your case going to survive? I think an apartheid case is not going to survive on, you know, aside from the political causes, but also on the jurisdictional ground. Foreign sovereignty and Kiobel and Daimler limitations and all of this. But if you look at the cases before this, what was happening was that the attorneys for the Palestinian organizations or entities were facing what I think is litigation fatigue or intimidation. And what they were doing is, before they were reaching the jurisdictional issue and the political issue, they were settling these cases for gross amounts of money. And this goes to the point that I don't recall who raised, of who are the lawyers that you are hiring on these cases. If these lawyers are not looking at the broad precedential impact and don't have a history of trying difficult, scary cases and knowing how to handle them and how to humanize the client and the communities that the client represents and the issues, and to fight tooth and nail on every evidentiary issue to appeal it, right, during the course of trial, to understand the broader impact, then you're bringing the wrong lawyers. And I've told people time and again, when the PA and the PLO and the Arab banks were hiring lawyers, yes, you were getting a white shoe firm that thought you were also a terrorist. And that's your problem, right? They were fatigued, okay, but you're talking about multi-million-dollar firms, but they went into the courtroom, and I've seen plenty of criminal defense attorneys walk into a courtroom on a terrorism case and snicker on the side, my client's a terrorist anyway. That's who has been and was representing, not just on the criminal end, but also on the civil end. Quite frankly, and we have to be, cognizant of the human bias. So it was, nice to see Ghassan Balloul, I don't recall the name of the case, Palestinian attorney. Yes, he worked for a white shoe firm, but he was a Palestinian attorney who did better in defending the case and fighting tooth and nail every issue, including jurisdictional. So yeah, I think that, as attorneys, we're all spent. It's very difficult for an attorney to be an activist. It means you don't have a life, but we do need to be prepared. And the clients and the community needs to understand that your people are actually your best weapon in these cases.
Thank you. On that note, Lamis, I just want to mention that usually Palestinian youth are discouraged to go to firms and instead go to the public interest aspect. But your comments honestly brought up the reflection that perhaps we should take spaces in those places as well to make sure that if in any case we have to go to these firms, we would be there to be a better advocate.
So I think the most important part of being a lawyer is having the right experience and access so that you can redistribute power. The power of an attorney is the redistribution of power to the masses, to the people, to the clients, to the communities that the clients represent. Is that possible within the framework of a white shoe firm? Perhaps. I mean, I don't know. Is it more likely in other contexts? Yes. Right. I mean, there's more limitations. There's also social, cultural, lifestyle changes that happen to people once they join white shoe firms that we have to be cognizant of. The separation between the attorney and the community is much more stark when you're dealing with a massive firm than when you're dealing with something mid-sized or small firm. So I'm not necessarily advocating, but it's not a bad thing that, firms are hiring Palestinians. When I was interviewing for jobs at law firms, I literally had potential employers ask me where I was from. And, then I have the pause of, okay, what do I say? Yes, I'm going to say it, I'm Palestinian. And, they raise their hands. I swear to God, they would raise their hands and say, oh, you're Palestinian. I don't want any problems. So it's a big jump to see that Palestinians are making it into bigger firms, that we're a bit behind that. Okay, that's nice, that's access. But in terms of serving the community and the cause and the issues, is that the most effective way? I'm not sure that that's what I would say, or that's what my position would be.
But you have to keep in mind the resources that are necessary that you would need to shepherdize to defend a case like against the PLO. There's no mid-sized firm, small firm that has that financial ability. So unless
but they're getting paid,
build,
they're getting paid multi-million. The PA, the PLO, the Arab Bank are paying millions of dollars to those lawyers.
No,
those
but they
law
have
firms,
the bandwidth.
That,
so the question is that they have the resources. Yes, they're getting paid for it, but unless we create a public interest law firm that's going to raise millions of dollars so that we can dedicate legal expertise representing these clients, we don't have the resources. Even if the PLO came and paid you $2 million, the team of lawyers and resources you need to put together, it's really not a simple.
They're struggling with this on another case, but realistically, there's also other formulations of what law firms look like, including law collectives. You look at the People's Law Office, you look at other law collectives that, I'm sure between us here, we've given multi-million dollars.
But the point that I'm raising
services.
is that the time has come that maybe we should put together a Palestine Legal Defense Fund so that we can have the resources and the expertise that we can go to the PA or high net worth clients that are being sued, and they could actually pay to sustain this Palestinian Legal Defense Fund. Because right now there's no everybody, it's you in New York, it's Akram in Boston, it's unless we can find a way to bring all of you guys together under one umbrella and raise the money, that will become a political and legal force to reckon with. And I'm very competent, and I know your competence. You're a pit bull, and I love your enthusiasm, your passion, and your competence. I would want to fund you. I would want to be able to say, here's all the money you need. Just dedicate your life to doing this, as opposed to most of us who are in this area. I mean, I'm in private practice, so I bill and I make a living. But most in the public interest, they're not making the money, and you guys do more important work than the work that we do. So I think this is a call to action for many of us potentially to get together and form a Palestine legal defense fund.
So I wasn't disagreeing with you, Abed, at all, and I strongly second. And I think a few of us here are involved. And I'll add, Dalaal and Hiba, if you're okay, Hiba, you attended the last legal committee meeting. Suzanne, I don't know if you knew about it, but there's been soft formulations and attempts to figure this out. And so my only distinction, Abed, with you is that it doesn't necessarily have to be like a formal firm, but there are collective ways that we could say, like you said, this sort of umbrella type of formulation that we need to start considering. You look at, Israeli law firms like Hurat Din, Shurat Hurat Din and Darihai Leitner, Nightmare of a human and an attorney. And no, truly, I mean, the judges said this. This is not just me. The judges have said, yeah, you're a nightmare of an attorney. You should be disbarred. And she should be. But yes, I think it's long overdue. The question always for me is, where are the resources going? And are we prioritizing the best use of resources is my concern. Should the PLO and PA have been paying more more effective, committed, true believer attorneys? Yes, that was a lot of money wasted. I see Professor Akram shaking her head. Yes, that money should have been spent on Dr. Akram and not on these racist, mostly Zionist white Jew attorneys who think that they're trying to save somebody. But you're absolutely right, Abed. And I think over the years, I know Dr. Anis is here. People have been trying it. It's hard, but inshallah we could do it. بنفسكم.
Inshallah.
Oh, that's beautiful. Again, I'm so happy about the brainstorming of ideas and suggestions that's going on here. And just would like to note that perhaps we could incorporate strategy and also that umbrella formulation of fund or guaranteed resources within that roundtable that Suzanne mentioned in Lamis. And Law for Palestine would love to organize that roundtable for you or help or support in any way. Just keep us updated. I think we are at the end of our discussion today. So please give me a moment to thank both of our panelists, Lamis Deek, Abed Awad. Thank you for our participants. Yeah, no, definitely. She's on the list.
She's a panelist today.
She is. So thank you, Susanna, for your intriguing questions and remarks. And of course, thanks for our broader audience who are tuning in or watching us live. And last but not least, we are grateful for the amazing interpreters with us today, Malik Diraniye and Zaid Dahbour, for their hard work. I guess this is goodbye. Enjoy the rest of your day, guys.
All right, it was a pleasure seeing all of you. Lamis, I'm back in New York, so let's get together.
Okay, let's aim for next week.
I'll text you.
That'd be great.
Okay.
Dr. Akram, thank you. Bye, Dr. Salman and Dr. Anis.
Thank you so much. Really a pleasure.
You're an honor. An Jad, national treasure. Allah